All right, next we have SNEAD versus SNEAD.
Good morning. May it please the court. I'm Andrew Bonderud, counsel for Michael SNEAD. He's present in court today in the gallery. Mr. SNEAD is the father and husband in this case, which was commenced on January 11th, 2018, when he filed his petition for dissolution of marriage. At the time, there were two minor children, who were subject to the proceeding. At the time of the petition, the older child was 2 years, 8 months old, and the younger child was 5.5 months old. The younger child is what brings us here today, JYS. JYS was born on July 27th, 2017 in Singapore. Mr. SNEAD is a citizen and resident of the United States in the state of Florida. His wife is, and at all times material, was a lawful permanent resident of the United States, resident of the state of Florida, and of Singapore, Singaporean national, Singaporean citizen. Both children have dual citizenship. Both children were born in Singapore.
Is the place of birth of JYS relevant in the UCC-JEA consideration?
Our position today, Your Honor, other than I wanted to provide some context, as I did in my brief, today we believe that really the only material inquiry under the UCC-JEA is whether or not JYS was physically present in the state of Florida within 6 months prior to the filing of the petition.
My question is, under UCC-JEA with the child less than 6 months old, is place of birth relevant at all?
No, Judge.
Doesn't mention it in the UCC-JEA?
Well,
I mean, that's not a factor you're supposed to look at?
Certainly not in the subsection that we base our jurisdictional argument on. So under section 61.514, Florida is the home state of the child on the date of the commencement of the proceeding. The circuit court in St. Johns County would have jurisdiction to make initial child custody determination only if any of the subsections applied. And we believe subsection 1A applies, and that says that the state is the home state of the child on the date of the commencement of the proceeding, or was the home state of the child within 6 months before the commencement of the proceeding, and the child is absent from the state, but a parent or person acting as a parent continues to live in the state. That's section 61.514. But looking to the definition of home state, which is section 61.503, subsection 7, home state means the state in which a child lived with a parent or a person acting as a parent for at least 6 consecutive months immediately before the commencement of the child custody proceeding.
JYS was not 6 months yet, so he obviously couldn't have lived 6 months in Florida, and factually he didn't live 6 months in Florida.
That's correct, Your Honor. And so in that circumstance, the next sentence provides that in the case of a child younger than 6 months of age, the term means the state in which the child lived from birth with any of the persons mentioned.
So he was born in Singapore.
That's
and
correct.
Lived for a period of time in Singapore before coming to Florida, correct?
That's correct, Your Honor.
Okay,
And
so that is something the court needs to look at, isn't it?
it's
I mean, that's a potential home state, correct?
It is a potential home state, and if the wife had commenced a child custody proceeding in Singapore, then arguably, if JYS was younger than 6 months of age, and JYS obviously had been present within the jurisdiction for some time within the initial 6 months of the child's life, then that court could have jurisdiction.
Also, you keep using the word present as opposed to lived, and you do that in your brief as well. But it's not present, because if it was present, I mean, Florida could potentially have jurisdiction over every child that comes to Disney World. So it's not present. So how are you defining that term lived?
Precisely the way that the courts in our state and other states have applied the term, removing the subjective intent and making it purely an objective inquiry.
Objectively, I think JYS was in Florida for about 48 days.
He came on October 27th, that's correct, and then
So-
departed in December with his mother.
So he was 5.5 months, and he spent just over 1 month in Florida. And you believe that that encompasses lived?
That's correct, Your Honor. And I believe, if I'm not mistaken, the UCC JEA provides what you might call a relief valve if the jurisdiction just doesn't make sense, if it makes no sense for the trial court to exercise jurisdiction, if it makes more sense for a court of another state to exercise jurisdiction. It's certainly reasonable for Florida. I mean, if a layperson were examining this from the outside, it makes sense that Florida would exercise jurisdiction. The trial court found that the marital home is in Florida. In fact, the trial court found that it has subject matter jurisdiction over the other child, and kind of engaged in a subjective inquiry to some extent, and took evidence on that. And there's no dispute that both Singapore and the state of Florida, that the parties have a lot of contacts, and indeed the children both have a lot of contacts with both jurisdictions. But what matters here is that Mr. SNEAD was the first to file. The child lived in the state of Florida within 6 months prior to the filing. And really for several months in the litigation, the wife agreed that the factual basis for our assertion of subject matter jurisdiction was correct. The wife filed an answer and a counterpetition, filed a UCC JEA in which she alleged that Florida and Singapore are both residences, which is not used under the subsection that we rely on. But really, there was no dispute for many, many months that the state of Florida is indeed the home state of both children. Only when we sought to take the wife's deposition locally did the wife then voluntarily dismiss her counterpetition, and we believe to some extent engaged in some gamesmanship and forum shopping, and decided that she didn't want to show up for a local deposition, didn't want to seek affirmative relief anymore, because that would, of course, require her to come back. And the wife has remained...
Subject matter jurisdiction be raised at any point?
It can, Your Honor. Yes, sir. It sure can. And so we don't think... it certainly was proper for the judge to consider the arguments in the trial court below. We just believe that the judge misapplied the law, and that it's not a totality of the circumstances inquiry, it's not domicile or residence, it's the physical presence test. And
where do you get that physical presence test?
Well, we cited in our brief a couple of cases that essentially use the same analysis as the Texas Supreme Court. The Texas Supreme Court spent quite a bit of ink describing the physical presence test, and Florida courts, including this very court in McCabe.
Right, but that was a different statute, right? McCabe was interpreting a different statute.
It was, Your Honor, but there functionally, and I think for all relevant purposes herein today, they're identical.
There's no Florida case interpreting the UCC JEA that has found the physical presence test applied.
Well, we believe that the McCabe test, for all practical purposes, applies a physical presence test. I don't know what else, even if it were called something else, essentially it results in the same outcome as the physical presence test in any conceivable case or factual circumstance where it provides for an objective inquiry. Was the child physically present in the state of Florida? And it's a pure textual application of the statute. The child lived in the state of Florida.
But
and
how
so
would
we
that be
checked box.
distinguished? I'm just having a problem with that. Physical presence in Florida. So vacationers, does Florida get jurisdiction over children on vacation here?
If I may,
I'm just trying to figure out where the line would be. If physical presence is the test, where is the line the court would draw on a temporary, short-lived physical presence? I mean, where is that line?
so I will concede that the statute specifically provides in subsection 3, and I'm looking at 61.514, a sort of relief valve where physical presence of or personal jurisdiction over a party or a child is not necessary or sufficient to make a child custody determination. And so there is a relief valve, I would say, in circumstances where it just makes no sense whatsoever for the jurisdiction to exercise subject matter, court to exercise subject
In
matter
the Texas
jurisdiction.
case, Brown, correct? That's the one you're referring to from Texas?
The Brown case is the one that, in Texas, yes, Your Honor.
That looked at whether the child was physically present within the jurisdiction for 6 months and found it wasn't. The child was not there for 6 months. You use that same test here. Was JYS here for 6 months? Answer, no. Brown says you lose.
Well, and that's because the child in Brown was over the age of 6 months. And here, you can apply the same rationale, except the child was under the age of 6 months.
How do you also then interpret the temporary absence from the home state? I mean, here was mom here with the child temporarily, so it's a temporary absence from Singapore, so therefore you don't even count that towards being in Florida? I mean, how do you deal with that?
Well, it's a fair question.
Thank you.
If the court considers also that the court found that Florida is the proper jurisdiction to adjudicate the parenting plan and child custody determinations of the older child, and that the older child's home state is Florida, and that any absence from the state of Florida was temporary, and the children have lived with their mother and father or their mother or their father for their entire lives, then it just doesn't make sense that Florida would be the home state of one child and Singapore would be the home state of another, and that we would have to petition for commence a child custody proceeding in Singapore for one of the children and Florida for the other, and the potential conflict. I just think that UCCJEA...
I agree that there could be some common sense there, and let's get it all done in one proceeding, which is typically what the law tries to do. But does the UCCJEA really permit that? Is there a provision that says if you've got jurisdiction over a sibling, you therefore have jurisdiction over every child of the marriage?
No, Your Honor, it doesn't specifically provide for that. However, I would say if lived does not mean what we what our position says it means, which is you were alive in the state of Florida, and no other jurisdiction has exercised jurisdiction or attempted to exercise jurisdiction. The wife has filed a counter petition for dissolution of marriage with the UCCJEA saying Florida is, and then if it's not what we say it means, then, and I know my opposing counsel is not here, but what other application of that or definition of that word could there be? It seems to me that the statute could have said been domiciled or resided or intended to remain, but it didn't. It said lived. And for a period of time within the 6 months prior to the filing, young Joshua lived in the state of Florida. He also lived in Singapore. And if the wife wanted to commence an action in Singapore, she could have, because young Joshua had lived in Singapore also. I can't conceive of another definition of the word lived, and that is, of course, the operative word that this appeal will turn on, we believe.
But counsel, doesn't the UCCJEA recognize foreign countries as the home state in terms of, for the UCCJEA?
It recognizes, and we have not, so the trial court found that Singapore is treated as a state for purposes of the UCCJEA.
Right, so the plain language of the second sentence of 61.5141A says, in the case of a child younger than 6 months of age, the term means the state in which the child lived from birth with any persons mentioned. So isn't that where the court hangs its hat and says, look, a majority of the time that child lived in Singapore, I'm bound to the plain language of this statute?
I'm sorry, you're in 61.5141A?
Correct. Where it says, in the case of a child younger than 6 months of age, the term means the state in which the child lived from birth with any of the persons mentioned. So aren't we... I'm
not reading that. In my 61.5141A says...
I think it might be...
Is that the home state definition in
Yes,
61.503, subsection 7?
Yes.
So in the case of a child younger than 6 months of age...
Right. So aren't we bound by... We all acknowledge that Singapore is defined as a state.
Yes, Your Honor.
And for a child less than 6 months, you've got to look at where the child has lived from birth. And the court found the majority of the time was Singapore, and that's what it hung its hat on. And we're bound to the plain language of the statute.
Except, Your Honor, it does not say a majority of the time. It says the state in which the child lived from birth with any of the persons mentioned. And it contemplates, the UCC contemplates that there could be more than one state that could be amenable to to exercising subject matter jurisdiction over children in a child custody proceeding.
And then the next sentence in definition of home state says a period of temporary absence of any of the mentioned persons is part of the time period. And wasn't there an issue in this case as to whether or not your client gave the wife permission to move back to Singapore with the children?
There was an issue with that, and that's correct, Your Honor. That doesn't, we don't read I think for the court to interpret the statute or construe the statute as Your Honor is right now would require the court to imply some additional terms into the statute that just aren't here, and it would conflict with this court's own precedents in McCabe and some of the...
What's our standard of review in looking at the judge's decision, taking into account the finding that she went back with his permission, going back to Singapore? I mean, isn't that consistent with this being a temporary absence from Singapore while she was in Florida?
So the standard of review, we believe, is de novo because it concerns subject matter jurisdiction, Your Honor. And in presenting this appeal, we're not challenging any of the factual determinations of the trial court. We're relying on the factual determinations of the trial court and arguing that the child lived in the state of Florida.
And with this, I mean, this is undoubtedly a very difficult situation for the family and your client.
Yes, sir.
If he chose to, he could go to Singapore and institute a UCC, a custody action there, or does Singapore not give credence to letting somebody come in and try to have custody of their child?
Well, theoretically, that is true, Your Honor, that Mr. SNEAD could go to Singapore. There are a lot of practical problems with that. Mr. SNEAD is not a Singaporean citizen. Just practically speaking, it's a really expensive place. He doesn't know anybody there, and it's entirely foreign legal system, and so we don't think it's a practical alternative.
Counsel, I know we're almost out of time, but just want to make sure I understand the position on what the definition. Under your definition, if a person had a young child, let's say 4 months old, and then born in Florida, family took them to Singapore, and they were in Singapore for 48 days, and they didn't come home, could the parent then file in Singapore under the UCCJA, arguing Singapore was the home state of this child?
Yes, Your Honor.
Okay. And you find that that would be fitting the same definition?
As I read it would be for the definition of home state. In the
Okay.
case of a child younger than 6 months, the term means a state in which the child lived.
Okay.
All right, thank you very much. Well
Thank you, Your Honor. Thank you.
We'll be in recess.